My name is John Corkery. I'm Associate Dean at the John Marshall Law School. And on behalf of our Dean, Gilbert Johnston, who's away, and the John Marshall Law School, I'd like to welcome you to this conference. This is the third Arthur J. Goldberg Conference. The title of today's conference, as you know, is International Trade and Labor, Leveling Up or Leveling Down. And we're very glad to have all of you here. We have a wonderful program. I'm going to turn the conference over to Jerry Brent, but I want you to know a little bit about Jerry first of all. Jerry Brent is a professor at the law school. He teaches contracts, labor law, collective bargaining, and labor arbitration, and also public employee labor law. Since 1986, he served as chairman of the Illinois Education Labor Relations Board. He's also been a labor arbitrator and mediator, chairman and executive director of the Illinois Office of Collective Bargaining, a member of the State of Illinois Impasse Resolution Panel, and counsel to a member of the National Labor Relations Board. He received his JD from the University of South Carolina and his LLM in labor law from New York University, and he's published 2 books and a number of law review articles. He's also a very fine colleague, and we're glad to have him here. And at this point, I will turn the proceedings over to Jerry Brent, who is the director of our conference. Thank you.
Thank you, John.
Okay.
Let me add my welcome. Welcome all. And we're trying to put together a more ambitious mailing list for this conference for the future. There are slips of paper out there by the door, forms that look like this, that will place you on the John Marshall Law School mailing list, and we would love to be able to inform you in the future of conferences such as this one that we will be putting on. So please take a moment on your way out and fill out the form, and simply leave it on the table that's out there. This conference, as Dean Corkery mentioned, is named for Justice Arthur J. Goldberg, who was United States Secretary of Labor under John F. Kennedy. He was an Associate Justice on the United States Supreme Court and Ambassador to the United Nations under Lyndon Johnson. The late Justice Goldberg was also, among his many other attributes, an outstanding member of the John Marshall Law School faculty in the 1930s, 40s, and 50s, and remembered very well by his alums. 2 years ago, the inaugural conference was devoted to Justice Goldberg's legacy to the American labor relations movement. Last year, the second conference was devoted to the Pullman strike of 1894. The proceedings of those 2 conferences are available in the John Marshall Law Review and also on videotape if you get in touch with the law school. This year's conference is devoted to several areas that intersect in the areas of Justice Goldberg's interests: labor relations, international trade, international law, and workers' rights. The conference's title is International Trade and Labor, Leveling Up or Down. Before I introduce our first speaker, I'd like to recognize the contributions of a number of individuals and organizations. First, this conference would not be possible without the financial contributions of private donors and organizations, and this year we deeply appreciate the continued generous support of the Chicago Federation of Labor and also the family of the late Justice Goldberg. Specifically, I'd like to thank Don Turner and Tim Leahy of the Chicago Federation of Labor and Barbara Goldberg Kramer, who is Justice Goldberg's daughter. We'd also like to thank the many individual private donors, donors whose contribution also make it possible for us to hold this conference without a registration fee. And I'd like to thank the Industrial Relations Research Association, and particularly Kathy Kwiatowski, for their help in publicizing the conference. We wish to acknowledge the assistance and support of the conference's advisory committee, the Law School's Board of Trustees, our deans and administrators for supporting the Goldberg Conference for this 3rd year, and a special thanks to Gary Watson and the Event Management Department for planning and coordinating another excellent presentation, our Publications Department for another exceptional brochure, our Public Relations Department for arranging the publicity, and our Media Services Department for providing the audio-visual support for this conference, including the videotaping. Professor David Stebbin of Ohio State University and John Marshall faculty Walter Kendall, Sandy Olkin, and Ralph Rubner provided me with many ideas, support, and advice for which I'm grateful. And Assistant Dean Bill Beach led the effort to fund this year's conference. Thank you all. Before we get to business, I want to take a personal moment to remember Louis L. Biro, who passed away last week. Mr. Biro was president of the John Marshall Law School Board of Trustees for over 32 years. He was a John Marshall alum and a great supporter of this conference. When we first proposed a conference named for Justice Goldberg, Lou stepped forward and asked to join our advisory committee, and he did so with great enthusiasm. You see, before Lou Biro graduated from John Marshall Law School in 1948, Lou had taken several courses from then young Chicago lawyer named Arthur Goldberg. At our inaugural Goldberg Conference dinner in 1999, Lou Biro related to me and to Ralph Rubner what it was like to be taught by Arthur Goldberg. He remembered that Goldberg was the school's best teacher, and I'm sure Lou was right. The law school and the legal community and this conference have lost a great public servant and a good friend in Lou Biro. With that introduction, I'm pleased to announce or introduce our first speaker, W. Gary Voss, who is sitting immediately to my left, your right. He is Vice President of Stetson University Law School and Dean of Stetson University College of Law in St. Petersburg, Florida. Gary has taught labor law, collective bargaining, arbitration, and other subjects at Stetson University College of Law for, I guess we would now say, over 25 years. He previously was a partner in a Connecticut law firm specializing in labor and employment law and business law. Dean Voss is a graduate of the Yale University Institute of Far Eastern Languages. He received his BA and JD degrees from the University of Connecticut and his Master of Laws, his LLM, and SJD degrees from the University of Virginia. He has authored many articles and books on labor law and arbitration, including a 2-volume treatise on labor and employment law in Florida, Law Policy and Practice. He is also a member of the National Academy of Arbitrators, and I'll add to the published information here, he is the longtime director of the Stetson Conference on Labor Law, which this year will be held in April, and I assume Clearwater Beach once again. And I have been to that conference both as a speaker and as an attendee, and I can tell you it's excellent. The brochures for that conference have been distributed. I'm very pleased to introduce Gary Voss.
Thank you very much, Professor Berendt, for that very kind introduction, and my thanks go out to John Marshall Law School for putting on this conference and for inviting me to leave sunny Florida in the middle of winter and come to Chicago. And I mean that sincerely. We have a little election controversy going on down there, and it's an appropriate time to absent myself from the campus. We're getting besieged by telephone calls, and tell you an interesting little vignette in that regard, not about the election, but about reporters. The first day this story broke, we began to receive telephone calls, and the first professor to field a call was our young environmental law professor. And he did a good job, and so now he is the election law expert at Stetson College of Law and has been quoted, I think, on the average of once a day since this process began. So that, I think, tells you a little bit about the election coverage. I'm delighted to speak at this conference today on international trade and labor leveling up or down, and therein lies the question, I suppose, and I hope to hear answers from some of my colleagues today on this distinguished panel. I have no answers myself, but I would like to provide a bit of an overview of the issues, if I may. 30 years ago, Harvard University economics professor Raymond Vernon predicted that increased international economic activity would create profound political problems. The proof of that prediction was manifested about a year ago at the World Trade Organization in Seattle and at subsequent similar events involving union labor protest. The WTO was formed in January 1995 as the successor to the General Agreement on Tariffs and Trade. It is the primary engine now driving globalization, and it is a democratic rulemaking body. It's part of the fabric of the rule of law that has spread over the world since the collapse of communism. I think that part of the frustration that labor has experienced, and one of the reasons that it has made an effort to link its goals with the WTO for enforcement of labor rights, is frustration with the current system, which basically provides no uniform set of standards and no enforcement mechanisms in that arena. The WTO obviously does have some powers. It has some sanction powers that were absent under the General Agreement on Tariffs and Trade. In 1994, as part of the complex negotiations in the closing period of GATT negotiations, there was some negotiation regarding labor standards. The negotiators basically agreed to formally exclude labor rights from the agreement. The sanctions, in other words, available to the WTO are not applicable to labor standards issues, as no doubt the labor, as the unions would hope. Instead, the negotiators agreed to include the issue of workers' rights on the agenda of the subsequent WTO negotiations. Now, one of the things I've learned as a dean over the years is that whenever we have an issue confronting the faculty that I would prefer to have go away, I usually assign it to a committee. And I think probably the same kind of reasoning went into play with the WTO in dealing with the labor issue. In 1996, at the WTO's first ministerial conference, the ministers of 128 countries reluctantly agreed to acknowledge, and I quote, internationally recognized core labor standards, close quote. But they refused to create specific standards or to allow sanctions. In its final declaration, made in December of 1996, the WTO made no mention of trade sanctions regarding labor, nor did it include any provisions for additional work on labor standards enforcement, other than a passing nod toward collaboration with the International Labor Organization. From the day that the WTO was created in 1995, the Clinton administration has lobbied for the inclusion of labor standards on the WTO agenda. With labor support a critical factor in the upcoming election, President Clinton made the inclusion of labor standards one of his major goals at the Seattle conference a year ago. By then, however, third world nations had solidified in their opposition to the proposed Labor Rights Committee, and the resolve of the labor unions and the environmentalists who believed that the WTO was running roughshod over the rights of labor and other individuals had solidified. As you know, several seaports were closed along the Washington waterways, and hundreds of longshoremen joined the massive protest against the WTO. It's very clear that labor has justifiable concerns in the trade arena. They have concerns about wages, benefits, quality of worker life, traditional concerns of American labor. Unions fear that low-priced goods produced with cheap foreign labor will unfairly compete with American goods that are priced higher because our workers are paid better and receive greater protections. They fear that capital flight will take American jobs to other countries. If the foreign goods are produced with labor that is well paid and with labor that is working under good benefits, under high workplace standards, then obviously the price of the foreign goods will be driven higher, thereby leveling the playing field. Many proponents of free trade argue that these negative impacts of capital flight and wage competition are non-existent, or at least are overstated. That's the argument. Others admit that while free trade may bring some undesirable effects for American labor, the benefits far outweigh the liabilities. Although many manufacturing jobs will move to less developed countries, workers in the United States, they argue, will move into higher skilled and better paying jobs. Now, this debate is affected by some dramatic, I think very dramatic, changes in power relationships in recent years. During the past quarter century, multinational corporations have gained considerable power as U.S. labor markets have become increasingly more globalized. At the same time, the relative power of national and subnational governments, states, municipalities, for example, and the power of trade unions have weakened in this respect. Labor justifiably fears a downward spiral of competition in which labor will be the ultimate loser. International attitudes also affect these power relationships and the changes that are occurring. The vast majority of the WTO's 135 members are developing countries who view the United States' efforts to raise the issue of labor rights as a mere pretext to legitimize U.S. protectionism. Many of the developing countries consider the WTO to be a club of rich countries that does not take into account the legitimate interest of the developing world. Arguments over the labor issues raised by the United States and its allies almost paralyzed the WTO Ministerial Conference in Singapore in 1996. The Director General of the WTO, the Director General designate at the time, also happened to be the Deputy Prime Minister of Thailand, a developing country with whom the United States has had a number of clashes over labor rights. The Director General designate cautioned that using trade sanctions to bolster labor rights would be, quote, highly detrimental, close quote, and that such a proposal could frustrate the launch of a new round of trade negotiations and cause some developing countries to simply walk away from the table. Other highly contentious issues before the WTO, such as the proposed admission to China to the WTO, may further fuel the flames of conflict between the U.S. and its labor unions against the developing world. And one may predict that after China becomes a member, China probably will take a very aggressive role in this debate. Part of the problem is that there is a popular perception, I think, that multinational corporations exist in something of a state of nature without regulation, virtually uninhibited by free market forces, free of national and international regulation. The truth is, however, that a tremendous amount of lawmaking has occurred since World War II, and a tremendous amount of institution building has occurred during that period, especially in recent times, to govern and at least to materially affect the conduct of multinational corporations. Much of that lawmaking effort has occurred outside the United States. Some of it, perhaps much of it, has been encouraged by the International Labor Organization. I suspect that most of this audience is familiar with the ILO, but perhaps we can take a moment and digress and give you a little bit of background on the International Labor Organization. Immediately after World War I, the parties to the 1919 Paris Peace Conference created a commission on international labor legislation. And the purpose was to examine employment conditions from an international perspective and to establish a permanent agency that would conduct such inquiries under the direction of the League of Nations. Well, you know the result of that process. The League of Nations never really took root. But this was the beginning of the International Labor Organization, and it outlived the League of Nations. Today, the ILO is a specialized United Nations agency based in Geneva, Switzerland. It consists of more than 170 members, member nations. It provides a comprehensive coverage of labor issues, more comprehensive than any other international organization in the world. The ILO International Labor Code, adopted in 1977, lists procedures for the review of labor standards and promotes generally a tripartite approach to the participation and consensus of labor rights groups, employers, and local governments. The ILO attempts to set international labor standards through more than 176 conventions and 182 recommendations. It also provides technical assistance to nations and administers vocational and management training programs. Now, the ILO really has very little by the way of sanction power. It really has no sanction power. Because the ILO does not suspend countries for failure to comply with ILO standards, the organization has very little meaningful enforcement powers. It can only make moral appeals. It can attempt to publicize violations by member countries in an effort to embarrass those member countries into compliance with ILO standards. The United States has, in my opinion, has shunned the ILO throughout most of its life, with the exception of a few areas. For example, the Abolition of Forced Labor Convention. By and large, the U.S. has failed to ratify ILO conventions dealing with the so-called basic human rights. Those human rights related to freedom of association, forced labor, equality of opportunity, and treatment. The U.S. has generally taken the position that it meets and exceeds the standards of the ILO in these conventions, and that has already enacted domestic laws guaranteeing these rights. Clearly, I think that may be true in some cases. In many cases, it is not accurate. The United States has more often preferred to take a unilateral approach in dealing with labor standards issues internationally and with sanctions. And this, of course, has created a great deal of conflict with our trading partners. I'll mention that in a little more detail in a moment. This causes our trading partners to criticize the U.S. for using its power to impose its domestic values and policies on foreign countries through such vehicles as Section 301 of the Trade Act. After World War II ended, the victorious nations basically established the General Agreement on Tariffs and Trade, and the periodic rounds of negotiations involved eventually more than 100 countries, and the focus was on trade and goods. Until the WTO agreement was reached, the GATT basically focused on goods. It did not deal with services, intellectual property, and other matters that had become so important in recent years in our trade picture. During this period, it became obvious that the limited focus on trade and goods was not adequate in dealing with the growing and expansive international trade arena. And so a number of nations began to turn quite early on to regional agreements. And I think the best example, without question, of a successful regional trade arrangement was the European Economic Community, which was founded in the 1950s. This ultimately grew into a massive confederation, a legal infrastructure of the European Union. Now, the European Union today governs not only trade in goods and services, but many aspects of the European labor market as well. The success of the European Community and its successor, the European Union, encouraged other nations, including the United States, to negotiate regional trade agreements. Although none of these agreements are as comprehensive or even close to being as comprehensive as the European Union. In part due to the very sensitive issues raised by domestic labor policies. Labor standards in general have been included in such regional agreements only as peripheral side agreements. For example, the North American Free Trade Agreement, NAFTA, includes a side agreement on labor rights called the North American Agreement on Labor Cooperation. This labor side agreement has been invoked a number of times in our relationships among the U.S., Canada, and Mexico, but it is extremely weak when it comes to enforcement mechanisms. Now, if we look beyond these major agreements, these major multinational agreements and major regional agreements, we'll find that there are a number of other areas in which nations have attempted to regulate international labor issues. Sometimes non-governmental organizations have become involved in the process. If you look at the government labor standards at the subnational level, we'll find that on occasion state and local governments, even in the United States, have attempted to involve themselves in the regulation of trade issues, sometimes labor issues. For example, during the campaign against South African apartheid, some state and local governments did adopt anti-apartheid policies that had an impact on labor rights. By and large, this has not been a very effective method for dealing with labor issues, and it does raise some federalism concerns. Non-government organizations, or NGOs, often have tried to get into the act, sometimes with success, sometimes without success. The anti-apartheid policies of some NGOs were successful in helping to influence the outcome of the political process ending apartheid. There are industry-wide codes of conduct developed on an industry-wide basis, sometimes by individual corporations, multinational corporations. Various organizations of private industries have adopted voluntary codes of conduct without the benefit of national or international legislative involvement. On occasion, the unions have been successful in negotiating with multinational enterprises to negotiate, in effect, multinational labor standards agreements. The success of this obviously depends upon the bargaining power of the individual union, and this has not been a widespread method for expanding labor standards into the international arena. The courts have been involved, but without a great deal of success from the perspective of labor. The judiciary may impose labor standards on multinational enterprises through case-by-case litigation. But in fact, if we review the history of the courts in this regard, the U.S. courts have not been very responsive to efforts to extend U.S. labor protections to workers in other countries, notwithstanding the fact that foreign workers may be employed by U.S.-based multinationals. There have been a number of cases in recent years in which the courts have applied a presumption against extraterritorial jurisdiction to preclude the application of many federal labor and employment laws to workers outside the United States. One area that has been productive and probably will not continue to be as productive in the future is the area of unilateral trade conditions imposed in U.S. trade policy. One of the most deeply resented initiatives of the U.S. government has been the linking of labor standards, labor rights, and other issues to trade rights in our dealings with trading partners under Section 301 of the Trade Act of 1974. Section 301 basically empowers the United States Trade Representative to threaten and to take retaliatory action against a foreign country to induce it to discontinue any act, policy, or practice which burdens U.S. commerce, provided it meets certain statutory standards. Now, the statute defines as an unreasonable act, policy, or practice a persistent pattern of conduct that, and then it gives a list of standards related to labor. For example, a pattern or practice or an act that denies workers the right of association or the right to bargain collectively. One that permits any form of forced or compulsory labor. Failure to provide a minimum wage for children, or failure to provide minimum wages, hours of work, and occupational safety and health standards for workers. Very clearly, an attempt unilaterally to impose U.S. values, labor standards to our foreign trading partners extraterritorially. A recent decision, about a year ago, a little more than a year ago, a decision of the World Trade Organization dispute resolution body held that Section 301 is discriminatory on its face and thus inconsistent with the WTO agreement, but they failed to strike it down because the Clinton administration had agreed to withhold application of 301 until the dispute resolution process procedures were exhausted. Clearly more than a shot across the bow. I think commentators generally agree that 301 cannot be for very long an effective threat in imposing labor standards in the international arena. There are a number of other statutes that have taken a similar course. For example, the U.S. Generalized System of Preferences program, the Caribbean Basin Economic Recovery Act, the OPIC, Overseas Private Investment Corporation Amendments of 1985, the Omnibus Trade and Competitiveness Act contains similar provisions, but none of these provide a comprehensive system for resolving the issue of how may we have uniform standards of labor protection at the international employment level. The United Nations has taken a number of initiatives in this area. For example, the International Covenant on Economic, Social, and Cultural Rights, the International Covenant on Civil and Political Rights, but these are fairly narrowly targeted and really do not have comprehensive application. As we may see from just a brief survey such as this, there has been a substantial body of rules developed relating to international labor standards, but none have comprehensive application. There is very little by the way of effective sanctions or enforcement. Although the WTO does have sanction and enforcement powers which might be expanded to the area of labor, there are other alternative avenues. And the WTO, at least for the short term, may be one of the least productive alternatives. I think one of the reasons why the WTO may be one of the least effective alternatives for the near term at least is that any attempt to harmonize labor standards at the international level across transnational boundaries must be tempered by the realization that significant differences in national economic systems stands as an inherent barrier to the harmonization of these rules. If you take, for example, the European Union and the relative success the European Union has enjoyed in this regard, this has been a very difficult process for the European Union to reach a level of harmonization of labor rules. And they have a long way to go. It's still a highly contentious issue, even in the European Union. But notable success has been achieved there, I think in large part because the European Union consists of member states with relatively similar types of national economic systems. They have similar national competition rules, and they have, despite some obvious differences, similar historical and cultural backgrounds. The harmonization effort, for example, in Australia and New Zealand has been facilitated by similar economic, cultural, social backgrounds of the member countries. The harmonization of rules across the U.S.-Canadian border would be relatively simple, I think, compared to the harmonization rules among Canada, the United States, and Mexico. Once you add Mexico to that equation, you have such a different economy, such a different history, different culture, that it will make it very difficult to harmonize rules. And so I would conclude that in those regions or organizations where the member countries are so dissimilar in significant respects, it is not realistic in the short term to expect progress on the harmonization of labor standards. This suggests to me, at least, that the development of trade and labor rules will proceed on a regional basis rather than on a global basis, and that the rate of progress will depend on similarities in the economic systems involved. The North American model of transnational labor regulation, represented in the NAFTA, takes into account the differences of the three economic systems. NAFTA represents a very different approach compared to the European Union. The cross-border application of labor laws under NAFTA is neither cumulative nor ongoing, as it is in the case of the European Union. NAFTA contains provisions for cross-border monitoring and enforcement of the respective members' own labor laws through a multinational tribunal. This model does not require the changing of labor laws so much in the individual member countries. In contrast, there's a determined effort in the European Union where there is greater similarity of the economies, competition rules. There's a greater effort there to actually harmonize the domestic content of labor laws. The NAFTA model, in contrast, does not seek to equalize or to establish minimum standards for labor rights among the three member countries of Canada, Mexico, and the U.S. It is the hope, of course, that that will be the ultimate result over a period of years, that there will be a harmonization process. Unlike the European Union, the agencies that were established under NAFTA, under the labor side agreement, do not have the authority over the actual labor standards of the member countries. There is no attempt under NAFTA to harmonize collective bargaining regulation or to bring labor conditions among the three countries into a state of equilibrium. In short, the NAFTA side agreement simply says that each country should enforce its own existing labor laws. And that's an oversimplification, but I think that's a fair characterization if I'm allowed to simplify. The history of enforcement of NAFTA and the side agreement raises serious questions whether this system produces any significant benefits for labor in the U.S. In the short term. I think that labor unions have finally recognized that one of the products of globalization is the weakening of labor's political power when the locus of political decision-making and labor regulation moves from a national to an international arena. Very clearly, the national labor movement in the United States has traditionally operated in a context of regulatory environment specific to this country, and the rules that are created in this environment have been determined at the level of national politics. When the locus of labor rulemaking shifts to the transnational level, all of those previous efforts to mobilize and to press for gains through the domestic political process may have very little impact on the transnational decision-making body or the tribunal. In short, the labor organization that focuses only on the nation state of its domestic jurisdiction may lose the political influence needed to influence transnational rulemaking. Let me just close by a suggestion in a thought, passing thought, and I'm sure my colleagues here, some will have a very different point of view. I think that one productive effort for labor might be to spend more time on the International Labor Organization. I know the AFL-CIO has been deeply engaged with the ILO. One of the reasons the ILO has not been more successful worldwide is the lack of support in the United States, lack of support of the U.S. government. If the U.S. commits to the ILO vision and receives the support of the American labor unions, the ILO will have vastly improved influence, and so will the United States. Thank you very much for your attention.
A bit of logistics. I think we'll wait until all of our speakers have spoken, and then we'll throw the floor open to questions from all of you, and also to any questions or exchanges that our speakers might want to engage in. We'd like to, at this point, before I introduce our next speaker, thank all of you who are in attendance here today for supporting the Goldberg Conference. I see many of our students, faculty from other schools, practicing attorneys, and other friends of the John Marshall community from government, and we welcome you as well. And I want to take the opportunity to just identify one individual without slighting anyone else, I hope. My mentor, Art Malinowski, is sitting down here, one of my mentors in state government. Art Malinowski of the University of Loyola is in the front row, and I appreciate him coming as well. Our next speaker is Don Turner, who is the president of the Chicago Federation of Labor. He's held that position since December of 1995. Before becoming president of the Chicago Federation of Labor, Don was elected the secretary-treasurer of the Federation. If you don't know about the Chicago Federation of Labor, they are the AFL-CIO's central labor body for Cook County. They represent more than 300 unions and over 500,000 workers. They have for over 100 years advocated the rights and interests of working people in the workplace and the halls of government here in Illinois and in Chicago. Don worked his way through college, was a member of the Steelworkers Union and the Baggage Handlers Union. He was a high school business teacher and became a member of the Chicago Teachers Union, was elected a union delegate in 1968. He has served as the CTU's Union Administrative Director from 1977 to 1984, and he was elected Chicago Teachers Union Vice President and Illinois Federation of Teachers Vice President in 1984. He left the CTU to go to the Chicago Federation of Labor, where he became assistant to the president and project coordinator. Don's experience outside of the union has also included a number of matters involving international business and international labor. He is a member of a number of committees and boards, including the Chicagoland Labor Management Committee, which is a combination, a partnership between the Chicago Federation of Labor and the Chicagoland Chamber of Commerce, which has been established to resolve shared employee issues and issues in the workplace. He has also been a member of Governor Jim Edgar's trade mission to Asia, Mayor Daley's trade mission to Mexico, and he served as an election observer in Nicaragua in 1989 and represented the AFL-CIO on visits to Poland for various purposes. And it's my pleasure to introduce the President of the Chicago Federation of Labor, Don Turner.
Take that with me. Good afternoon. Many thanks to the members of the Goldberg Advisory Committee for your kind invitation to attend this conference. Particularly like to thank Jerry for opening up the law school. It's kind of commendable and refreshing to see a law school opened up to the labor movement the way you've done, Jerry. And I think it's important also that you've included the labor community in important discussions like this. And I have to say that you've even opened up your classes to those of us in the labor movement, and I think that's been really commendable on your part. So I'm delighted to join this distinguished panel. I was particularly impressed with Gary's speech. I mean, wow, to have such an expert on this subject is really impressive. I have to say, Gary, I learned a lot since this is my full-time job from your presentation. I thought it was terrific. But I'm here to express labor's view on open markets and free trade, and I suspect there are going to be some disagreements with the people on the panel. And I'm sure we can all agree that neither the existence of open markets nor their value can be taken for granted, but I would like to make a few observations about this situation. When we talk about globalization, we must hold a constant awareness that all the world's people do not share the same cultural values that we have about it. The world is shrinking, but just because people are sitting there watching CNN and drinking Coca-Cola doesn't mean that this superficial westernization has changed some deep-rooted cultural attitudes about economics or politics or a lot of these other cultural issues we have. So when you hear the media trying to blend these diverse cultures, I think we have to keep in mind that there's going to be a lot of tears and a lot of conflict about this blending process. The effects of globalization on workers does create a new reality. Globalization is a process of breaking down trade barriers between national economies. From our perspective, it's driven by a corporate agenda, and it's accelerated by changing technology. The global economy is a reality, and I think it's pretty much dominated by United States and foreign multinational corporations, and that in itself makes it unlikely that it will go away. So, from our perspective, the rules of global trade have to be defined, and the benefits have to be demonstrated. If it's left to expand without rules or with the wrong rules, we believe that globalization will produce an inevitable downside. What I'm saying, I guess to simplify it, is that there's a difference between trade and development. And yet at the same time, these two things are linked together. But development is not always sustainable, so we must keep that in mind too. Also, it's our view that an unregulated global economy will produce a growing income inequality within nations and between nations. And this inequality in the United States is approaching an all-time high, or certainly as high as it's been in many, many years. And it does seem that the long-term trend line for this inequality within the United States is growing. And it also seems that that trend line, this growing inequality between nations, is growing. If we look back to 1960 and we took the top fifth of the world's economies and the bottom fifth, there was approximately a 1 to 30 difference in terms of the value in those economies. Now we're looking at about a 1 to 80 difference. So we see this differential between the economies increasing. So we look at it and we say, look, the downside of globalization on working families is real and it's very pervasive, and therefore we need some kind of changes in the rules. So we look at it and we say what we need is a new approach. We need a new internationalism, if you will. We need to establish some fair rules that make the global economy work for all, and that this challenge is similar to the challenge that workers faced at the beginning of the 20th century when they were dealing with the long-term product of industrialization. That then the challenge was the power of big monopolies and the formation of some kind of integrated national economy. And now it's the power of the multinationals and their capital. And what we need and we're seeing is the formation of an integrated global economy. And the question that we see is, what kind of rules will this globalization have? What will they be and who will set them? Will they be private understandings between CEOs or heads of state, or will they be the result of an open, democratic process? But I do know that if labor itself is not involved in this process, that you can be sure that this process will be dominated by corporate interests, and it'll probably be a much more secretive and less transparent process than if we are involved. So what are the fundamental tests of globalization? We say it's not whether markets are more open or less open. We say that mistakes the means for the end. The test is human development. Is it helping to lift the poor from poverty? Is it empowering the many, not just the few? Are its blessings widely shared? Does it elevate working people? If those things happen, I think we can say it's a success. But if they don't happen, then I think we can say we have to look at it in a suspect way. Now, I mean, just as an aside, I think the American view on this kind of parallels the world view in some ways. There's a tension, if you will, between our individual hunt for personal wealth and our sense of civic and community purpose that we're about, where we define success by how much we cherish the individual's ability to grow, the community's progress. Are we sharing responsibilities as a community? We weigh that against this kind of individual personal wealth. And I think to put it differently, we could say, are we going to respect the fact of wealth or the how of wealth? That's the way we would look at it. Now, I know that in the last few years, greed has kind of been mainstream. But I think we have to look at it and say, is that the value that we want to enshrine? Is that the value that we see as the fundamental purpose in our democracy? And I think if we say no, it's not, then we have to say we have to put some limits on corporate power and corporate ability to make these kind of decisions affecting this globalization process. In short, we should measure the success and the strength of our democracy by the fortunes and the future of the middle class in this country. The scope of opportunity offered to each child, whether that child realizes his potential or not, we should measure it by its access to providing for the American dream, and not on the basis of whether it provides a lot of lavish wealth to a very small elite, whether in this country or in another country. So I think we have to look at this a little different. Now, Gary touched on it. Trade can kill jobs, and it can depress wages. R.C. Longworth, in his book on the global squeeze, talked about it, and he mentioned 4 ways in which this happens. Number one, we have a company here that, in order to meet foreign competition, puts in labor-saving devices, and those labor-saving devices drive people out of work. So that's one way in which it happens. That one factory job, if you will, we have this spin-off. You know, the normal ratio is 1 factory job to 4 jobs outside. And so when that one factory job, we lose that one factory job, then we lose 4 spin-off jobs. And all you got to do is drive to the south side of Chicago and look at the area where the steel mills used to be, and you see that pretty clearly, that those other 4 jobs have left. Those jobs were in restaurants and banks and so on. So that also depresses job creation. We also have the fact that the threat of competition keeps wages low. And we see that at the bargaining table, those of us in the union movement, that we find ourselves in competition. In some cases, what we feel are unfair wages coming in from overseas. And the question is, you know, how are you going to compete with those wages and so on. And you can't negotiate better agreements for your people, even if you have an inflationary economy, because of that. And of course, last but not least, that as wages fall because of this depression, then other kinds of jobs leave too, you know, the neighborhood bookstore, that type of thing. So wage floors, where you have a major social safety net like they have in Europe, are probably not as important as they are here in the United States, where there's less of a social safety net. So wage floors become a much more important thing in our economy, would be the way we would look at it. And you know, we're not against growth, but certainly growth is a speed. It's not a direction that we want to take things. I mean, cancer is growth too, but that's not the direction that we want to go. So. You know, we have to look at this thing with a different slant. For this new internationalism, this new globalization to benefit all of us, we think it has to contain 3 elements. One, we have to have effective laws that secure basic human rights, environmental safety, and consumer protections. Number 2, we need some kind of sensible financial market regulation. Some places have tried it, like Chile, where they said, you know, investments in the country, you must keep them here at least a year. You can't just pull them out and so on because of disruption to the local economies. There's been some attempts, but those have been essentially national attempts to deal with it. And number 3, there need to be some core international labor standards, such as freedom of association, right to organize and bargain collectively, prohibition on any forms of compulsory labor or prison labor, we would say, or child labor, and certainly the end of discrimination in employment for women and other groups. So from our perspective, having labor standards is a win-win situation. It's a win situation for the workers in the developing world. It's a win situation for the workers in the developed world. And we think these labor standards are necessary in order to shift the global economic development into a path that is fair and sustainable and stable for the long haul. The opponents to this viewpoint will undoubtedly bring up some arguments against core labor standards. One of the arguments that you hear is it's nothing more than disguised protectionism. Well, there's 50 ways to leave your lover. And there's 50 ways to keep foreign imported goods out of the United States without resorting to labor standards. We have an open economy. This economy imports 1/2 the goods exported from the developing world. And certainly any kind of sanctions that we applied resulting from violations of labor standards they wouldn't make a dent in our life here, but they might serve to change behavior in those offending countries. So that's one possible way to look at it. And we also have to note that the ILO, the International Labor Organization, did adopt what they call a solemn declaration with respect to promoting these labor rights and to realize good faith and a fundamental set of rights and principles at work. The opponents also say that labor standards are better handled by the ILO, but as Gary pointed out, the ILO does not possess, nor does it wish to possess, the capacity to enforce labor standards, and without enforcement, labor standards themselves are a sham. At some point in the process, there has to be a fair and transparent enforcement mechanism that would be necessary for it to work. At least that's our view. Opponents also say that incorporating labor standards would be difficult, especially given the structure and the dispute resolution process that's available in the WTO. Well, it would be difficult, but you know what? It wouldn't be impossible. Other subjects like international property rights, intellectual property rights, bribery, corruption, email, commerce have been successfully introduced. They've been put on the agenda of the WTO, and certainly labor rights should be possible also, given the fact those other things have been done. What is required, however, is the requisite political will to execute the process. The opponents also say that labor rights are not the same as intellectual property rights. There are some valid reasons for including intellectual property rights in the WTO. First, international variations in the IPRs clearly and directly influence trade flows, and certainly we could say that for labor too. That suggests that they fit within the purview of the trading system. Another thing is that the international policy coordinating problems in the IPRs arena seems particularly sharp, but I think that we have that sharp kind of difference in the problems of coordination too for labor standards. So I don't think that that would be overwhelmingly difficult in order to solve this. We in the labor community believe that core labor standards should be in the agreements for the following reasons. The primary reason is that it's morally correct. Without international standards, the unequal power relationships would continue to produce conditions ripe for the exploitation of workers around the world. In the words of Sister Susan Mikva, founder of the Coalition for Justice in the Maquiladoras, morality does not know borders. It's unconscionable for multinational corporations to behave differently in developed countries than in less developed countries. As Robert Reich said, former Secretary of Labor, child labor is a moral issue. It is a moral issue. So why shouldn't there be an international standard? Children who work in the fields in the United States, in the agriculture field, is that a moral question? Of course it's a moral question. And the same thing would apply internationally. It's a moral question because in a country as prosperous as us, it's a moral outrage to see children in the field of agriculture out there working in the fields. Secondly, labor standards are consistent with sustainable development. Research has shown that observing fundamental workers' rights is good for growth. It's not an obstacle. And that strong democratic institutions, smooth economic transitions, they aid in crisis management. Protecting worker rights contributes to the development by building popular and stable democratic institutions. It decreases inequality, and encourages political participation. Labor organizations can also and are fundamentally important in bridging ethnic and religious differences in the workplace and push for greater and public-private investment in education, in training, and economic growth. In addition, they contribute to the development of a strong middle class in countries where they are established. This will result in real trading partners who are more likely to buy and purchase United States goods. Third, labor standards prevent good companies and good countries from the need to compete with those who have chosen the low road to economic development and economic profit. No country should be allowed to attract investment on the basis of repression of workers' rights. Fourth, A mechanism is needed for the more equitable distribution of benefits of trade. If the benefits of trade continue to go to the wealthy few, a national consensus supporting U.S. trade policy will never be achieved. You know, the preamble to the Constitution in the United States starts off, "We the people." It doesn't say, "We the investment banker," or "We the multinational corporation." It talks about "we the people." And as Pope John Paul XXIII said, economic prosperity of any people is to be assessed not so much from the sum total of goods and wealth possessed as from the distribution of those goods according to some norms of justice. So, are there precedents for including labor rights in trade agreements? Certainly. Gary mentioned many of them. I'd like to add a couple more to the huge bag that Gary filled. The McKinley Tariff Act of 1890 banned the import of goods that were produced by prison labor. We also had the Tariff Act of 1930 banned the import of goods made by forced or indentured labor. We actually had a side agreement in the NAFTA agreement that covered labor. Obviously, we would have felt better if it was in the agreement rather than a side agreement. But there is a history of dealing with this issue, and I think that one looks at it, it really is a question of political will more than any other single issue to put it in the agreement. The international labor rights are clearly an idea we feel whose time has come. It's time to stop talking about the problems of incorporating labor standards into the WTO and time to do something about it. Pardon me. The global market has been forged primarily in the last 20 years. And what's happening is it's now being called to account. And I think Seattle was a wake-up call, a political wake-up call, that suggests that the current course of action cannot be taken for granted. Seattle was important. Protests in the streets by workers, environmentalists, farmers, students from across the world were mirrored and angered inside the hall by developing countries, by the delegates from those countries, who felt that they had been just as locked out of the process as the demonstrators who were on the street were. So if we care about some kind of equitable, sustainable development, and then the impact on people, not only on their incomes, but on the environment, health, food safety, democratic participation, as well as the urgent issues such as debt forgiveness, then these things can't be left to chance. So understand the message of Seattle. It wasn't an isolationist rejection of open markets. It was a call for new global rules. Workers in the North and the South and from many parts of the world marched together. And all these voices together made one clear statement. The current course of action is not sustainable and some kind of fundamental reform is needed. Now, we give markets their due. We understand that they're not perfect. They're far from perfect. They're just a system of getting the buyer and seller together. That's all these global markets are. But they have little to do with decency or equity or our religious values. They really don't concern themselves much with community interests like child care or national holidays or transportation or voting procedures. They don't have any moral dimension. It's just a system to get the seller and the buyer together. So clearly, from our perspective, we have to do better. And if we don't, and if this global system continues to generate a growing inequality, if it continues to generate environmental degradation and destruction, and if it's a race to the bottom, then I can assure you it will generate an increasingly violent reaction that will make Seattle look pretty tame. In the short term, I think there's going to be more losers than winners. In a democracy, when we count all the ballots, the majority decides. And it's not an accident that the nations that are most supportive of globalization are the most developed nations, those that have the greatest social safety net. And But as globalization grows, we're going to have more and more dislocations. David Marquand, a British sociologist, said that we have two choices. We're going to either tame globalization or we're going to tame our democracies and make them function differently. And he may be right. I believe all of us need to think about this in a new way. Leaders of global institutions are facing a legitimacy crisis that can only be resolved by doing something in a different way. It won't be resolved by a public relations contest, and if they don't try to resolve it, their institutions are going to become basically irrelevant. So leaders of developing nations are going to face a growing inequality of income and hope. They're going to need jobs, and they're going to need to preserve their democratic institutions. They should not be forced into some kind of an economic straitjacket by trade. And Gary touched on it. But what is happening is leaders of individual countries have less and less control over their futures. And what is needed is some way for them to reach out and put bans on this and get it contained in such a way that they still have some control over their futures. So they have to see some tangible benefits. The countries that adopt labor reforms have to see some tangible benefits, environmental advances and things of this nature. There has to be some way in which we reward the world community. The world community has to reward developing nations if they're going to be part of this process. They can't see it just be a rush to the bottom. So global non-governmental organizations, what we call NGOs, have raised some very legitimate fundamental concerns. And why are the NGOs developing is because they speak for a broader constituency. There is a limit to how far your national governments can go. So NGOs and the internet quickly have made them world players, and they've banded together, and they're trying to address things that can't be addressed through the normal political process, or a process in some cases that's dysfunctional. So it's important now, we think, that NGOs go from opposing what is, they have to start proposing what should be. So we think that would advance the case. They must not assume that the price of development requires that we cash in our basic human rights or our democratic ideals. Heads of global corporations and banks should not be misled by their rhetoric. They'll be held accountable for how they do business, increasingly by consumers who advocate boycotts of their products and so on when they're made with child labor elsewhere in the world. It's one way in which we in the labor movement plug in so we can address the process, because it circumvents all the other hoops that you have to jump through. So in a sense, we're going to take our story to the street and to boycotts and bans on products and so on this, and bring up the state of how that company functions in a third world country. You're seeing that by consumers, by workers, by environmentalists, and I think increasingly you'll see it by governments too. Leaders of corporate communities have to join to build some kind of enforceable laws that put limits on cutthroat competition, so that it's not to a company's economic advantage because they gain a couple of pennies on a product to go to a third world country and pollute the environment in that country, or to abuse workers. They shouldn't be permitted to do that. So I think that, and most of us feel in the labor movement, that some kind of rules are going to have to be agreed upon by these entities. Labor leaders across the world must also change how we meet these new challenges. At the AFL-CIO, we know that we have to deepen our commitment to a growing internationalism, to develop a new sophistication in bargaining and organizing across national lines. We also recognize that we must join our voices with those in developing countries calling for high-road development strategies. Pardon me. We must work to ensure that developing countries are no longer crippled by unpayable debt burdens, and that they have the resources needed to engage in trade negotiations on an equal footing, including technical support to implement and enforce labor and environmental agreements. Seattle did mark a crossroads. Joined by millions of others across the world, labor pledged not to rest, but to continue to press for core workers' rights that are the basis of economic freedom and equitable development. In this panel, at this conference, I'm sure I raise one voice, but I'm sure that this voice is also shared by many and growing numbers of people both in the United States and around the world. We're joined by people who believe in workers' rights internationally, who believe that environmental rights should be sustained, and that believe that these rights should be enforced in a global economy, and we believe these rights should not go unheard. So let us all agree on one thing at least, that if we're going to have a global civil society, that business as usual cannot be the order of the day. The global economy will either be reformed or face even greater resistance at home and abroad. Thank you.
For some of you who may have come in later, we have on the table near the door these small forms to get on the mailing list for this conference and other programs, and we encourage you to fill them out so that you can get on our mailing list. I'm going to violate the logistical rule I set up. I see that we're about 5 or 10 minutes ahead of schedule. We were going to take a break, which we will do in a few minutes, but I could see from body language out in the room that there are a number of people who are likely to have questions for our first two speakers. So I'll open the floor for that in the event that any of the people who were shifting around in their seats or shaking their heads in agreement or in disagreement wish to ask questions of either Gary Voss or Don Turner. If you do wish to ask a question, I'd encourage you to step forward to the microphone that's in the center aisle so that you can be recorded by the video equipment.
Hi, my name is Janice Thomas, Foley and Thomas. I have a question for Mr. Voss and for Don Turner.
Yes.
Don Turner, you mentioned a wage floor, and I don't understand what your analysis economically was of that as far as the World Trade Organization, and if the wage floor functions differently in Europe than it does in the United States, what is the policy of the Richard Daley administration?
Don, you can answer from there.
Right. When I talked about a wage floor, what I was talking about there was the way in which the laws were structured in that country to support a minimum standard of life for people in that country. And that was why my reference was that there is especially if you think about issues like national health care and pension systems and so on, there's a higher wage floor in Europe than you would see in the United States. But certainly that's important to workers who may be facing dislocations. And in terms of it here in the city, I'm not too sure that I quite understand your question on that in that regard.
Well, there's been proposed a living wage in Chicago. What is the position of the Daley administration?
Well, the city of Chicago has adopted an ordinance, a living wage ordinance, and I think it pegs the living wage at around $9.75 an hour. I believe it's something like that. And that would be a base wage that the city would apply to contracts where the city is involved in purchasing. That would be the minimum dollar value that workers would have to get in those contracts. There is no provision in there, however, to pensions or health care for those workers and so on. So what you're talking about is that would be the minimum floor. That was the city's attempt to raise the standard of living for a number of people in the metropolitan area, and that would be similar to what I'm talking about. But I think in terms of trade, you're really looking more at national standards rather than a regional standard or a city standard.
Are there any other questions? Professor Mock, I think you're...
Yes, I'm Bill Mock. I'm on the faculty here at John Marshall. The basic premises of free trade, established since David Ricardo, have been that the more free the trade, the greater the wealth generated by that trade. And Ronald Coase got his Nobel Prize for essentially saying that if we increase the size of the pie, there is bound to be some way we can redistribute it so there are no losers.
That's an Italian version of trickle down, then.
Perhaps, I'm not sure. Sounds like it's the wine that should be trickling. But the heart of the debate ever since Coase has been how to achieve this redistribution. More for Don Turner than for Gary Vaus. Is your presentation premised around the idea that there has been a failure of the redistribution, but that indeed the basic premise that more trade produces more wealth is accurate, and therefore we need to focus on the redistribution and perhaps to some extent forego the increased wealth for moral reasons? Or are you challenging the basic premise that the increase in trade will itself increase wealth that is then available for debate?
Okay. As a general rule, trade increases wealth, as a general rule. But to say that first of all, who does it increase wealth for would be one question that we would like to see answered. Our view is if you build a middle class, if the well-being of the middle class improves, that is a good trade policy, whatever that may be in the particular. But if the well-being of the middle class deteriorates and we see that that wealth is increasingly focused in the hands of fewer and fewer people, and you develop a wealthy elite in this country, or the country that is sending the goods, that is not a healthy thing for the long-term sustainability of your communities and so on. So if we looked at a trade policy, there's a fellow that wrote a book called In Praise of Heavy Industry, for example, Eamon Fingleton. And what he outlines is a case where you have a trade policy that may be in the process of decimating your heavy industries. And he outlines why this is destructive to your economy long term. Well, that would not be a trade policy that I would like to see in place, because it would contribute to the overall decline of the middle class in your country. But on the other side, if we developed a trade policy where we, let's say, had it in conjunction with a tax policy, so you had rapid write-offs and you saw your manufacturing industries increase, and in a sense, by doing that, increase the prosperity for the people in your country, the middle class in your country, then I'd say you had a good trade policy. You know, we're not opposed to trade just in a knee-jerk way. In fact, we have a huge percentage of our members whose livelihoods are based on trade. But it's more concerned about the how of the trade, and are we selling out particular industries, and who made that decision to do that? You know what I mean? We want to be part of the process by which this occurs. We don't want it to occur in some back room. You know, it's amazing to me, you know, I'm probably one of the few people in America that actually read the NAFTA trade agreement. It looked like a phone book. Oh, there's two of us in this room then, okay? And, well, as you well know, what would happen is you would get to a particular page and you would read about asparagus and how we were going to phase in asparagus over 6 years. And why were we going to phase it in over 6 years? Because the time it takes from putting a corm in the ground, which is the basic asparagus root, to production was 6 years. And so these guys who had asparagus farms had to make their investment 6 years ago to realize a profit today. We took all that into consideration for asparagus farmers. But there was nothing in that agreement that dealt with the lives of working men and women in this country, and I think that was wrong. And we're saying for this process to work, we have to be part of the process, and the rights of working men and women to make decent livings is just as important as it is for that asparagus farmer. And unless the benefits of trade are going to be shared and elevate the whole society, I just soon not have it. I want it, we encourage it, but I think it's ultimately destructive to our way of life, to our democratic institutions, if that doesn't occur. And, you know, we have to look at it differently. We have to look at the impact of the trade long term. And we're not opposed to it. We're absolutely not opposed to it. I would estimate 25% of our membership, especially in the manufacturing sector, maybe higher, is livelihoods depend on trade.
We have another question from Robert Fitzgerald.
Not so much a question as an observation as to how it's going to work, because the ILO recently reported that since 1990 through 1999, when the U.S. economy has been booming, the rest of the world did not share in that, because they estimate 200 million additional people in the world went into extreme poverty, not just poverty, but extreme poverty. So I think it's a question of how the wealth from the increased technological and other trade is distributed. It's just not being distributed properly, at least in the last 10 years.
Thanks, Bob. If you don't know Bob, Bob is a practicing attorney here in Chicago, a labor lawyer, and a member of the adjunct faculty of the John Marshall Law School, and taught labor law before I got here. That's right. There was another question I think I saw back there. Victor Blackwell, who's the executive director of the Illinois Educational Labor Relations Board.
That asparagus comment reminded me of my friend's venture in ostrich farming. You have to get started early, and you have to know when to stop too, I guess. This is for Don. Don, how do you reconcile the union's ability to effectively boycott corporate America in view of imperialistic effects relative to capitalization in underdeveloped countries? And I guess maybe to sort of break that down a bit, how do you foresee the union being effectively boycotting when just with the capitalistic development in the underdeveloped nations now, of course they'll be selling Coca-Cola in other countries too, you know, smaller underdeveloped countries.
Well, you're actually hitting the core issue. Labor institutions were essentially developed to meet the problems caused by industrialization as we move from a rural to an industrial economy. And it took us, if we think about the beginnings of industrialization as probably a few years before the Civil War, it took us into the 1930s to get some kind of reasonable labor laws to deal with the situation. Not that people didn't try to deal with it, and we had issues like child labor in the intervening time and so on, but it was a time of great struggle to deal with what were really massive social changes, and that's what's happening now. All of those constraints that were put on capital are national. They're all within your country. But now what's happened is capital has gone international, and so the question is, how do we contain the worst degradation that you get from capital? We have, like, I think it was Gerber Foods that filed a charge against the government in, I think it was Nicaragua, because the Nicaraguan government actually had a campaign out there to promote mothers breastfeeding their babies as compared to using their product. And this was like a restraint of trade issue. I mean, if you can believe it. But is that an example of a corporate excess? Absolutely, no question about it. So I think what we're looking for now is a set of rules and a political strength within the labor movement. And so how are we building that strength? Well, we're connecting up with labor groups elsewhere in the world. We're trying to develop a nascent labor movement in third world countries. We are trying to partner up with other groups like environmental groups, NGOs, and so on, to look at how to contain this monster. Now, we're not against the monster. Look, it's the goose that laid the golden egg. I mean, capitalism lays the golden egg, and many of us, our lives are enriched because of it. But they're enriched because we contained it, and we contained the worst excesses of it. And what we have to do here is to figure out some set of rules that are not national but that are international that contain these worst excesses. Should a company get an economic advantage because they use child labor in a third world country against a company who isn't doing that in the same country? If the wages for a child worker are less than an adult in that country, and one company, a company that's in a sense operating correctly and employing adults, and another company gets an economic advantage of a penny an hour, should we permit that? I mean, should we permit that, or should we have some method by which we contain it? You know, so I think the question is here is, are we going to permit companies that go into a third world country and pollute or use child labor or prison labor? You know, because in some of these countries, I mean, the business community to some degree would like you to believe that the more we promote trade, the more we promote democracy. But that isn't what happens. What happens is, in many countries, the money goes to an elite in that country, and they use it to oppress people even more because they have the money, they have the power, they control the police forces and so on, and they arrest people and they use prison labor and they do all these terrible things. It doesn't promote democracy, it promotes the opposite. Should somebody or some corporation get an advantage because they go to a country like that? I don't know. I mean, we have to develop some mechanisms. We have to develop some mechanisms. Overall, the idea of capitalism, does it deliver the goose? Is it the goose that laid the golden? Yes, it is. But we need some way of containing the worst excesses.
Tim Leahy.
Tim Leahy, Chicago Federation of Labor, and I just wanted to add two insights that I thought might be helpful for the audience here. Two things. One, at the end of World War II, when Japan was going from an imperialism monarchy to a democracy, one of the first things that General MacArthur did was call Truman and said, get some labor leaders over here. He requested that they send over some U.S. labor leaders because they knew for sustainable democracy that they needed a trade union movement. Second, which goes to Don's point about freedom of association, how important it is. Second, Don and I were in Seattle, literally on the streets, sitting down. And it was a
Sitting
great,
down?
Yes, it was a great, there's nothing like good old American dissent. But during that in Seattle battle, President Clinton spoke, and he was pretty well beat up by the press about intervening and speaking and mentioning to the WTO ministers that there's a reason why there's 100,000 people outside. But I remember one of the columnists, Bill Sapphire, who's not exactly a progressive Democrat, hasn't been exactly one of Bill Clinton's best friends, he said finally Bill Clinton did something right. And he said that free trade doesn't deserve to wear the banner of free trade if it doesn't promote freedom of association, if it doesn't promote democracy and freedom. So I think that's a thought we should all consider about when we talk about free trade.
Thanks, Tim.
Gary, just to expand on that for a moment, it's very interesting. If one looks at the countries that have the strongest labor movements, those countries have the strongest democratic traditions. Where you have a weak labor movement, you have a weak democratic tradition. And that's universal. And it's also interesting to note that if we look at where political oppression was, South Africa and Poland, basically it was corrected, not because of corporations, but it was corrected because of the labor movement involvement in those countries.
Gil Feldman.
Gil Feldman, Cornfield and Feldman. I have a question, and if anybody can give me an answer, I think you deserve an international prize. What I heard at Seattle from third world countries was that they have a difference in what is an unacceptable labor practice than modern developed countries do. And some came in, and I recall they said to us, child labor is what we have to sell. If you take away our right to sell child labor, then the work which we have is going to be removed from our country and taken someplace else, and our standard of living is going to be reduced, not elevated. Now, since you're going to be negotiating between the developed countries in the world and third world countries of that type, how do you negotiate when you have countries that are so disparate in terms of existing conditions?
Two comments. One, that's basically the same argument we heard in the United States about 1900 when we were debating child labor. It's essentially the same corporations said, oh, if we eliminate child labor, we're going to go out of business, we won't be able to compete, and so on. Secondly, as the business community is always fond of telling us, we're the buyers. We can just say, we don't want to buy from you if it's made with child labor. Now, is that going to drive what happens over there? Yes. But on a more practical level, that's where the value of the NGOs come in, because many of the NGOs are monitoring these very self-same things. And even now, corporations, many of them are developing independent monitors that go out and check their factories, their plants. Are they using certain kinds of labor and so on? So there is a process by which this is beginning to be addressed. And I think we can address it in large part, too, by just saying we're not going to buy those products. You know, if we know those products are made that way. And it's interesting because in the Kathy Lee Gifford case and the Nike cases and so on, there is an awareness on the part of the American public and also the world community on these issues. And it's becoming more apparent. You know, when the public hears about it, in terms of corporate campaigns and so on, they're addressing the issue. So, yeah, it's less than perfect. It's less than perfect. But
if I could make a couple of comments on that. Americans, when we have debates, we tend to cast our positions in moral terms. And that has happened, I think, in the international trade labor debate. And that doesn't play very well with those with whom we're negotiating typically. I have a fair degree of experience in Thailand, and in fact co-authored a book with a Thai professor on Thailand's labor laws. And one of the things I've learned over the years in working with the Thais is that the fact that they have child labor and that they follow standards of labor that are far lower than ours, that would be unacceptable, really does not suggest a lower moral standard for the Thais. And I think the Thais and any other developing country, any other nation, takes tremendous offense when we cast our arguments in international trade in moral terms, which is a tendency I think we all have. That's the first point. The second point is I think it's no longer possible today, it may have been possible 20 years ago, but it's no longer possible for the U.S. to simply say, if you do not subscribe to the standards that we subscribe to, or which we set as minimum standards for our partners, that we will simply not trade with you, because we are now part of a very complex multinational scheme in which we have pledged to give equal treatment to the products of all members of the WTO and various other agreements, interlocking agreements we have. And so I think it's not so easy to simply take the moral position that if you do not subscribe to our standards, we will simply not buy your products. The WTO panel decision more than a year ago on the Section 301 dispute, I think, established very clearly that we cannot take that position now that we might have taken 20 years ago. I'm simply making these remarks to suggest the complexity and the difficulty in negotiating these standards with our trading partners.
Could I speak on behalf of Greed is Good?
As a matter of fact, Wally, I was going to say, let's open this up because I could tell from some of the comments that they called for a response.
Some of you may remember the movie Wall Street, where the Michael Douglas character, Gordon Gekko, delivered this wonderful speech that is amazing in its breadth and audacity, but it started with the sentence, "Greed is good." I'm not here to defend greed, being a good Catholic boy, but there's something to be said for profit, particularly since it's now estimated that 44% of all Americans own stock, either directly or indirectly through their pension funds. But I wanted to talk a little bit about this business of child labor. First of all, I can't remember whether Gary or Don mentioned that we banned the importation of products made from child labor back in the 1930s. Secondly, in June of last year, with the endorsement of both the AFL-CIO and the U.S. Chamber of Commerce, the U.S. Senate ratified the ILO Convention on Child Labor. So there's not, people want to beat this horse, and I'm telling you it's a dead horse, that American business is in favor of child labor. The facts don't support that, Kathy Lee Griffin notwithstanding. The second thing that I wanted to point out, I'm surprised that my friends in labor, when they talk about this other mechanism other than national governments has to be put in place to enforce environmental standards and labor standards in other countries. Well, if it's not a national government, then what mechanism is it? Are we talking about world government? I'm a little surprised to hear our friends in labor advocating that. The third thing I'd kind of like to point out, just as a matter of history, the ILO, well, let's talk a little bit about trade law, since I assume all of you are lawyers and I'm not. The Reciprocal Trade Agreements Act of 1934 is really the first body of modern trade law put in place by Franklin Roosevelt. In 1935, the United States had not been, because we did not sign the Versailles Treaty, which set up the League of Nations and the attendant organizations, we were not a member nor represented at the ILO or the IOE, which is the International Organization of Employers. Franklin Roosevelt designated his close personal friends, all those Republicans across the street at the Chamber of Commerce and at the National Association of Manufacturers, to designate the business delegation of the U.S. delegation to the ILO, which we first went there in 1935. We continued to do that until 1972, when Richard Nixon took the United States out of the ILO because they were concerned about it being a little too leftist or socialist. So the ILO has had a checkered history, but nevertheless, it is where the three parties, according to the European concept, to economics come together: business, labor, and government. So there are three parties that participate in the ILO. Quite frankly, we at the Chamber have delegated our responsibilities on this to another business association in New York, because quite frankly, we haven't seen a lot of positive things, or a lot of threatening things coming out of the ILO for the past 20 years or so. They have new leadership there and will probably get more involved. But the one thing that Gary said is absolutely right about Section 301. Section 301 came about as part of the Trade Act of '74, which came about, and also in that thing was something called Fast Track. It was a creation of Richard Nixon. He never got it. Gerald Ford got it because he resigned. But the whole Trade Act of '74 was in reaction to the Congress, and Fast Track was in reaction to the Congress taking a GATT agreement and saying, we don't like this, go back and negotiate, we want to change these sections to such and so, go back and renegotiate with the then 26 members of the GATT. So that's why Fast Track came along, so the Congress couldn't tinker with trade agreements that had been negotiated. 301 was something that labor and business very much wanted because we were dissatisfied with the GATT. And 301, as trade law, was despised by our trading partners, especially the Japanese and the Europeans, because we unilaterally, as they put it, were judge, jury, and executioner. We said, you have unfair trade practices. We've done a 301 investigation. It's unjustifiable practices. We self-initiate the action. You have no private right of action, and we decide that we're going to impose 100% tariffs on $4 billion worth of duties. And that was unappealable to no one except the U.S. Trade Representative. So it was an enormous hammer that we used all through the 70s and the 80s. The trade-off in the Uruguay round was we wanted a dispute settlement mechanism in the WTO that had teeth in it, that didn't take 10 years to come to a conclusion. And the explicit deal that Mickey Cantor hammered out in Geneva was the trade-off between U.S. unilaterally using the 301 club and us having faster, more definitive dispute settlement mechanism. Well, we got what we asked for, we in business. And by and large, I have to say that we've been satisfied. From a labor point of view, because there were, as you pointed out, there were a whole list of labor-related standards that were in 301, although if you look, very rarely was 301 invoked to impose actual sanctions before for those labor standards or violations of those labor standards. Labor lost that. But so did American business. It was I can remember when we sat down and read the Uruguay Round Agreement, there were some companies in the room, when they looked at the dispute settlement mechanism, they said, oh my God, we got everything we asked for. So we had to give up 301. So 301 now occurs after you go through the WTO dispute settlement process. So that's just a way of giving you a little bit of history and background and try to put this in a legal construct. The thing that's fascinating about this trade and labor issue is because it's not cast in concrete or in international law. This is a work in progress, very much in progress. And, you know, other than the ILO back in 1919, there is not a huge body of international law, standards, or practices that you can look to. Thank you.
Thank you. I'm going to exercise my privilege. This is a work in progress as well, this conference, and I had promised that we would take a short break. Why don't we take that now? Please come back. Mr. Workman will lead off the commentary when we come back. 5 minutes. Our break is ending. We're going to get back to business. If you'll all please return to your seats and get comfortable. Our next speaker is Willard A. Workman, who goes by the name Wally. And Willard is the Vice President and General Manager International of the U.S. Chamber of Commerce. There he is responsible for the formulation and implementation of the Chamber's policies and positions on international economic and trade issues that confront the United States business community. He has also served as Vice President of the Center for International Private Enterprise, which is affiliated with the Chamber of Commerce and is dedicated to assisting emerging private sector and market-oriented groups in the developing world to establish market-based democratic systems. Mr. Workman joined the U.S. Chamber of Commerce in 1988 as Director for Policy and Programs in the International Division. Before he joined the U.S. Chamber of Commerce, he was a special negotiator for international trade controls with the United States Department of State. He has also worked as strategic or Director of Strategic Planning and Policy at the Bureau of Export Administration in the United States Department of Commerce. And while he was at the Commerce Department, Wally Workman was also the Senior Policy and Program Analyst to the Assistant Secretary of Commerce for Trade Administration. Mr. Workman served in the U.S. Customs Service, where he was involved in operations planning for then Vice President George Bush's, that's the first George Bush's, South Florida Task Force on Drug Interdiction, and the development of the 1982 Federal Drug Enforcement Strategy. And from 1974 to 1980, Wally held various program and management positions at the U.S. Department of Justice and its Law Enforcement Assistance Administration. We're very pleased to introduce Wally Workman.
Well, thank you, Jerry. And before all that, I was a spy. No, true. I'm going to give you, hopefully, if this works right, a multimedia presentation. But I wanted to start off a little bit by talking a little bit about some of the difficult decisions or problems posed by the issue of trade and labor and the intersection between the two concepts. This is a live issue. This is not going away. It's a live issue because we have concluded a free trade agreement with the Kingdom of Jordan, which incorporates into the text of the agreement for the first time in U.S. trade agreements provisions dealing with labor standards and environmental standards. It is a continuing issue because this past Monday, U.S. and Singapore negotiators sat down in Washington to negotiate a free trade agreement between the U.S. and Singapore. And the U.S. Trade Rep's position is that we want to use the Jordan Free Trade Agreement, or FTA, as the boilerplate or the model for the Singapore FTA. It is an issue because next year the free trade agreement between the United States and Israel will come up for renewal. And I would imagine that the Histadrut in Jerusalem would be very interested in having labor provisions in the U.S.-Israel FTA. It will come up in the context of discussions and attempts to amend the bilateral trade agreement between the U.S. and Vietnam, which was negotiated actually a year ago and finalized this past summer and will come before the U.S. Congress sometime in the year 2001. So these are issues that are Boxlight, huh? Presenting a better way. It's not what it shows here. I don't know who Boxlight is. There we go. Well, that's who I am. Anyway, it will come up as a question as to what do you do, for example, in Venezuela, where President Chavez conducted a plebiscite where he basically disempowered the CTV, which is the traditional labor organization for Venezuela, and has replaced it with his own trade unions. This is something that has been the people at the ILO in Geneva have spoken out. The European trade union movement has spoken out against this. And the whole issue of Chavez and his Bolivarianism, son of Fidel Castro, is an issue that's of some import. It raises tough moral questions, like, for example, when the AFL-CIO filed as a petitioner under the worker rights provisions contained in the Generalized Systems of Preference Act, and claimed that the Lukashenko regime in Belarus was not allowing the free assembly of trade unions and what have you. Lukashenko doesn't allow the free assembly of anybody. I mean, this guy is someone who keeps a picture of Stalin next to his bed at night. So they filed. USTR took it up. There's no denying it. What was the practical effect on 118,000 workers in textile and apparel shops who worked for American companies in Belarus? They all lost their jobs. So the net effect is, were they a real threat to U.S. textile and apparel workers in the United States? I don't think so. The net result is you have 118,000 Belarusians who will never join a trade union. So, I would submit that maybe great motive, bad tactics in that situation. So those are the kinds of issues that flow around trade and labor, trade and human rights, trade and religious freedom, trade and environment, and what have you. What I thought I would do is not give you a legal presentation. What I thought I would do is talk a little bit about this new international economy and what it means for business, for labor, for the environmentalists, for those in the legal profession, what have you, because it is a considerably changed world than it was just 10 years ago. And just to punctuate it, just so you don't think all my material is dated, this is out of today's Washington Post, and it says, global trade expanded this year at its fastest rate in more than 3 decades, pushing economic growth in developing countries to above 5% this year and probably next year. This is from the World Bank. The 120 low and middle income countries in Asia, Latin America, Africa, and Eastern Europe will see their economies grow at their most rapid pace in more than 20 years, up from an average of 3.4% annual GDP growth to over 5%. This is part of the World Bank's Global Economic Prospects released yesterday afternoon. So just to give you the backdrop to some of this. What I want to do very briefly today is to talk about these several topics. It's my view that there's a new relationship between the public and the private sectors. I want to take a look at the challenges and opportunities that are confronting business, because after all, I do represent business. I want to talk about the rise of small business. I would take issue with the fact that trade is predominantly for the large multinationals, and I'll speak to that. I want to talk about our allies who are also our competitors. I want to talk about the hunt for investment, which everybody is doing, including the United States. And then take you on a very quick tour of the world. The thing about the Gulf region, forget that. I'm not talking about the Persian Gulf. I was down in New Orleans last week and I had to speak to the Gulf of Mexico, but I forgot to take it off the slide. So anyhow, new public-private relationship. We have a completely free market, basically, in capital. In capital, both in terms of bucks and in terms of technology. And it has grown incredibly rapidly over the past 25 years, particularly since Nixon let the currencies, the US dollar float in 1972 or 73, and basically put the IMF out of business, because the IMF was established to stabilize currency rates. If you have a floating currency rate, then you don't need the IMF. So they've been searching for 26 years for a new mission, and they found a lot of missions, but that's another story. To give you an idea of the difference between the public and the private sector, the second bullet is instructive. Chase Manhattan, in 11 minutes, will process international financial transactions that exceed the annual foreign aid budgets of Europe, Japan, and the United States. It's 11 minutes versus 12 months. And Chase Manhattan Bank is not the largest money center bank. The other thing about this new relationship between the public and the private sectors, the private sector and the public sector, if you screw up, you are, in this new economy, you are punished instantly. If you make corrections, the turnaround time for you to recover has improved dramatically. Specific examples: 1982, Mexico had a peso crisis, had a financial crisis, and they devalued the peso, and it spread throughout Latin America. And basically throughout the whole 80s, Latin America was in deep depression. As a matter of fact, the Latin Americans refer to it as the lost decade. Finally, around 91, 92, they began to turn around. In 1995, Mexico had a peso crisis, another financial crisis. They stuck with the commitments they had made under the NAFTA agreement, and they implemented some new improvements. Within 19 months, Mexico went from negative GDP to positive GDP, as opposed to 12 years. In 1997, Thailand, Indonesia, Malaysia, and South Korea had financial crises. Those countries, of the four, the two that instituted broad economic reforms, tough economic reforms quickly, their economies turned positive GDP growth within 21 months, as opposed to 12 years in the case of Latin America in the 80s. 1998, August, Russians had their financial crisis. And they, what's his name, Primakov, at least kind of stuck with the good economic policies that had sort of maybe been put in, but more importantly, didn't do anything bad. The Russian economy has turned to positive GDP growth in 22 months. So even in the Russian example, where the government essentially was almost dysfunctional, you have this rapid turnaround. Now, what does that mean for business? What does it mean for the public sector or governments? Businesses, by and large, don't really understand why this is happening. But because they have to make business decisions on a day-by-day, hour-by-hour basis, all of them have come up with some kind of model that they follow that works for them. And so they muddle through. Governments are still debating, what should we do about this contraction of the time? We don't have the luxury of sitting down and having hearings and having studies conducted to think about what we're going to do as a matter of public policy. Because by the time you go through that cycle, your 19 to 22 month window of opportunity is gone. So that's a challenge to government. It's a challenge to business. It's a challenge to a lot of the other shareholders in this thing. Let's talk a little bit about the rest of the world. Much has been said. The reality is 96% of the people of the world live outside the United States. And that's a market that we in business don't think we should forego. There are two ways to look at these three statistics. They're either a problem or an opportunity or both. Being in business, we tend to look at them as a problem that is an opportunity. But this is not made up. These are pretty standard statistics. And everybody wants to talk about email and the internet. It's kind of hard to do business on the internet if you don't have a phone. It's also kind of hard to do business on the internet if you can't read. So 50% of the world's people never made a phone call. They don't have access to the vaunted telecommunications system, and the bulk of them live south of the equator. Half the people of the world don't have access to electricity on a daily basis. Kind of hard to operate your computer if you got no electricity. 11% of the people of the world have never owned a car, a bus, a truck, a motor scooter. So those are in areas in telecommunications, in power generation, and in auto manufacturing where American business is very competitive. And so we see that as enormous opportunities, and we want access to those markets. Small business. What you may not know about the Chamber, because everybody assumes that the U.S. Chamber represents big business. Well, we do, and I'm here to prove it to you. Sure, we have the Fortune 1000 as companies, as members of the Chamber. We also have 129,000 other companies who are members of the Chamber, and 96% of them are small businesses that employ less than 100 workers. 60% of them are small businesses that employ less than 10 workers. So our view is skewed heavily not by the multinationals, but by our small business paying members. Within the United States, you have the Fortune 500 or the Fortune 1000, and then you have 18,999,000 1,000 other companies who are not the Fortune 1000. Over time, and this is the only statistic that we have on this, between 92 and 97, we've seen a doubling of those small businesses who are directly related to exports. This does not say anything about those who are involved in imports or who are involved in secondary functions related to trade. We do know, looking at the trade statistics, that of the roughly $500 billion in exports that we did last year, about a third of them were done by small companies. The trend line is up for the small guys. That is also where the jobs are created. The Fortune 1000 have been losing jobs steadily for the past 25 years, and that trend will continue. In fact, there are more people employed by companies, by women-owned businesses than are employed by the Fortune 500. So if you want to know where the employment generation is, and these are not hamburger flipping jobs, these are high-paying, high-wage jobs. Where our jobs are being generated is small business, not the Fortune 1000. Now let's look at our friends and neighbors. And we have to look at the European Union. Its GDP is larger than us, even when we add Canada, where they managed to count 13 million, hand count 13 million votes earlier this week in 4 hours. And even if we include Mexico and Canada. They have a plan. It's called Project Europe. It preceded the European Coal and Steel Community, which was formed in, I think, 1955, and with 5 members, and eventually grew to the current 15 members. They have arrangements, what they call association arrangements, with 7 countries or 5 countries in Eastern Europe. And they have accession agreements where they will be joining the 15 in the core union, but they're not limiting themselves to Europe or Eurasia. They have negotiated free trade agreements with Mexico. They are negotiating some kind of a framework agreement with the Mercosur countries, which includes Brazil, which accounts for 60% of the GDP of all of South America. So Brazil is important. They are trying to include themselves in the Pacific, in some of the various trade forums there. So they are looking beyond the Eurasia landmass. Whereas the U.S., once we finished NAFTA, which was negotiated in 92 and passed the Congress in 93, other than the Uruguay round, we have essentially done nothing since NAFTA went into effect in 1994. So we are now almost 7 years behind the line in terms of looking at what the Euros are doing. The EU is not shy about picking fights with us. And you must know that politically, we have to pay attention to them. The only piece of legislation that the Congress has passed since Election Day, other than continuing resolutions, is a rewrite of the Foreign Sales Corporation Act, because the EU took us to the WTO and found that, got a judgment that the Foreign Sales Corporation, or FISC, tax scheme was an illegal export subsidy, so we had to change it. So that is the only thing the U.S. Congress has done in terms of legislation since our election on November 7th. There's a reason. The European Union has a right to impose tariffs on over $4 billion worth of our goods going into the EU. So the relationship is a robust, mature relationship between equals, with the situation right now being that the EU is a little more equal than the U.S. Japan. It's the second largest national economy in the world. and will continue to be that until about 10 years from now when China will overtake it. But it is a very strong competitor to us. Of the 19 critical technologies that the U.S. Defense Department identifies, the Japanese have the technological lead in 7 of the 19. So they're no slouches. They've been in a 10-year recession, but even at that, they are formidable competitors, and Japanese business is beginning to say, to hell with you, Japanese government, we're going to do what is in the best interest of our stockholders. A novel concept, by the way, in Japan. The Asian tigers. As I said, Korea has made a remarkable turnaround, as has Thailand. Taiwan, which is the largest investor in mainland China, and Hong Kong continue to be vibrant economies and major trading partners and competitors of the United States. Future competitors. On the top of the list has to be China, but they're going to be competing where they have a comparative advantage, which is in labor. So I don't expect to see them, I don't expect to be buying a Chinese car anytime soon. I expect to continue buying footwear, T-shirts, and low-cost consumer electronics from China because that's where their comparative advantage is. India is a sleeper. India basically has kept itself isolated from the world. We are the largest trading partner with India, and last year we exported $3 billion to India. To give you a comparison, we export $3 billion a year to El Salvador. We give foreign aid to Israel, that's $3 billion. But they are coming out of their self-imposed import substitution approach to trade. And they have, remember, this is 1.1 billion people. They have a middle class with purchasing power comparable to the U.S. middle class of about 135 million people. Their middle class in absolute numbers with the same purchasing power is the exact same size of the American middle class, even though it only represents probably maybe a small percentage of the overall population of India. Brazil, as I mentioned earlier, Brazil is you can't think about South America unless you think about Brazil. Brazil will be a difficult trading partner. We already have a lot of disputes with them, and they are not anxious to open up their markets. Russia, 170 million Russians. In many areas, they are still ahead of us. If you're going to launch a satellite and the launch vehicle that's going to put up the satellite, made by Lockheed Martin, but it has Russian G4 rocket engines in it, you get a 20% discount on your insurance. So just to put it in realistic business terms, there are a lot of things that the Russians do where American business is already collaborating and working with them. It has enormous potential. If you haven't been to Russia, you ought to go. And the people are wonderful. Hunt for investment. Everybody likes to talk about investment. Half of all American private sector foreign direct investment, and that's coming not only from American companies, but from pension funds, is in the European Union. 45% of all EU foreign direct investment is in the United States. So the challenge when we pick a fight with the Europeans is to make sure that we're not fighting with ourselves. And the same is incumbent on the Europeans. I can tell you that this recent spat of trade disputes that the European Commission, which is the technicians and technocrats in Brussels, is cooked up, has European business in a tizzy because they're going to be hurt, for example, on the Foreign Sales Corporation spat as much as an American company is, because their American subsidiary is not going to be able to use that tax scheme. So in some sense, them is us and we are them. We have been extraordinarily successful at attracting in recent years foreign direct investment from the European Union. Part of it is that we're viewed as the safe haven. Part of it is the Europeans are looking at the investment opportunities and the business regime in the European Union, and they do not find it to be business friendly. A German automotive company told me recently that they have no plans to either invest in new or expand existing German auto plants in Germany proper for the next 20 years. That they actually found the business environment in France better, which floored me. And of course, their prime location would be the U.S. It's no accident that you've seen German auto companies coming to the U.S. over the past 5 to 10 years, because the return on investment, the safety of the investment, the way investment is treated in this country is the envy of the world. We need to attract this kind of company of investment because we are running a horrendous trade deficit. When we had the Asia financial crisis, everybody was concerned about being inundated being inundated with cheap Asian imports. Well, what actually happened was we were inundated with expensive European luxury goods. Everybody went out and bought Mercedes and BMWs and what have you. So it always pays to look a little closer to these figures. Let me talk a little bit about when a company is making a decision to invest. And I'm talking bricks and mortar. I'm not talking about speculation in portfolio investments. There is something that we've put together at the Chamber that we call the 12 Commandments of Foreign Direct Investment. And these are rules that companies use, all companies, American, Latin American, Asian, European, everybody uses at least these 12 criteria. Labor and raw materials are only one of the 12 criteria. And I'm just going to read you the short titles, and this is common sense. This is not anything that a finance professor in business school would base a course on, but it's just simple. They look at the size of the internal market where they're going to make their investment. Is it a big market, little market? What are the opportunities to use it as a base to export into adjacent markets? They look at freedom of access to the market. Can they get in the market? Are there restrictions? Are there licensing requirements on investment? They look at the labor force and raw materials. If their business activity requires raw materials, is it available and what does it cost? If they need a skilled workforce, is it available? If they need a low-skilled workforce, what is it and how much does it cost? 4, they look for protection from currency devaluation. That makes sense. You invest $100 million, you build a plant, and the next day they devalue the currency by 50%. You've lost half your investment overnight. They look for the ability to remit dividends, interest, royalties, and technical assistance payments. Basically, if you put your money in, can you get your money out? They look at property rights protection, not only intellectual property rights, but real property rights. If you have some people going around confiscating plants and houses and equipment as well as CDs and software, you probably wouldn't want to put an investment in that country. They look at the export potential. You build a plant there, can you not only service the market, but can you export back to your home market to service your production needs there? They look at the regulatory burdens. And that in and of itself can sour many companies from investing any place in the world. They look at taxes. Again, this is common sense. You come to Cook County to invest in Chicago, you want to know what the tax structure is and what kind of tax breaks you can get or what have you. They look at political risk. Is Chavez going to be around in 2 years in Venezuela? Are they going to continue to rewrite their constitution every 16 months, as has been the case? Number 11, they look at macroeconomic management. They look at the central bank. What are they doing on interest rates? They look at the government. What is the fiscal policy? Are they running government deficits or surplus? And finally, they look at the infrastructure support. And infrastructure is not only the legal and regulatory infrastructure, it's also nuts and bolts. In terms of the state of the world business, I read the thing at the opening about the World Bank, what their predictions are. Generally speaking, we have to look at where trade is concentrated. And trade is concentrated in the northern hemisphere. And you saw this play out in Seattle. And I was in Seattle too. I not only got tear gassed, I got pepper sprayed. So it was really an eye-opening experience. But I would agree that I think the media, while they focused on a few toughs breaking into Starbucks, I would agree with Don, that the real story was inside the conference center. And you saw this very clear, determined divide between North and South, developed and developing countries, and they absolutely do not believe that we will not use either labor standards or environmental standards as a protectionist device. And when the president unfortunately made in what he thought was making a statement that wouldn't be carried worldwide, when he said directly that he hoped we would be able to use trade sanctions to enforce labor and environmental agreements, that's when the conference exploded. And the delegations that were in my hotel went home. So it wasn't Ambassador Barshevsky's inability to get the folks into a meeting room. It was Bill Clinton confirming what all of these developing countries feared. Now, I'm not saying that that it's their approach and their fears are rational or legitimate, but they're there, and they feel strongly enough about it that they broke up what the big guys wanted, which was another multilateral trade negotiating round. And they denied that to the big guys, which is the Quad, which is basically Japan, Canada, the U.S., and the EU. So we didn't get what we wanted. So that's something that we're going to have to deal with. The areas, when you talk about the developing countries, let's talk a little bit about what they're interested in. Coincidentally, these happen to be the basic building blocks for any modern economy in the new global economy. You got to be able to feed your people. So they're interested in anything in agribusiness. And that's everything from the seed to the fertilizer to the farm machinery to food processing. You got to get your food to market. So we're talking about transportation. We're not talking about airports. We're talking about road, rail, waterway. Telecommunications. You got to be able to communicate the signals of the market. So for that, you have to have a modern telecommunications system. Number 4 goes hand in glove with number 3. In a modern world, you can't do adequate financial services, banking and insurance, unless you got telecommunications. And then finally, you got to have electricity to run all this stuff. Those happen to be the 5 sectors where in almost every sector, U.S. companies are the preeminent, most competitive suppliers in the world. So I want to, again, reemphasize, this is something that we don't want to let go by. This is what we're putting at risk if we continue not to engage in trade negotiations or global commerce. Where do we go from here? And this is the next to last slide. We have to continue to work within the WTO because it's basically a creation of the United States. It's one of these cases of you ask for something and, oh my God, you got it. It's just like, I can't remember whether it was Don or Gary, they were talking about we want the NGOs to be more involved in the WTO. I remind you, Don, that the U.S. Chamber is an NGO, so you may get what you wish for. There is a problem with the WTO, and that was identified in Seattle. It is a consensus-based decision-making organization. Everybody agrees or nothing is agreed. That is a weakness. It was okay when you had 20 members of the WTO. When you have 138, it becomes so unwieldy that it's probably unlikely we are going to get another big round agreed to by all 138 countries. So we're going to have to find another mechanism. I don't know what it is, but we're going to have to find that. We still have regional rules. We can still use Section 301 against the non-WTO member countries who are predominantly in the developing world. The problem is we just don't trade that much with them. So 301, which is imposing punitive tariffs on their exports into our market, they don't sell us very much. It's a limited weapon there. This is a big thing for business, and I think it should be for labor as well. The Clinton administration claims to have negotiated over 300 trade agreements in the past 8 years. They have no idea what they are. We asked for a list, and they can't give it to us. We would like to know how the other parties to those trade agreements, are living up to the agreement, to the contract. So at least in business, we're going to push next year for let's enforce the agreements that we have. The American Chamber of Japan, did a study 2 years ago where they looked at the 36 U.S.-Japan trade agreements, both sectoral and general, and found that only 12 had been partially implemented, and the others were just basically ignored. So that's not a very good track record. Finally, what are we at the U.S. Chamber doing? We do our thing through our affiliate, the Center for International Private Enterprise, which is part of the National Endowment for Democracy, which was created by the Republican Party, the Democratic Party, the AFL-CIO, and the U.S. Chamber in the Amway room at the U.S. Chamber building in 1982, overseen by Dante Fascell and Bill Brock. As Dale Bumpers of Arkansas said, an unholy alliance of parties, big labor, and big business. But we promote democracy, and we work with our friends at the Solidarity Center at the AFL-CIO to do that, and have done a lot of good work together. We also have business development initiatives initially in Thailand, and this is for small businesses, not for the big guys. But also in January, we'll start one in Singapore. We also have an information technology and a biotech business partnering initiatives. This is basically where I get somebody, either the U.S. government or the Singapore government or the big guys in information technology, to pay me money to help American small business partner with small business in Singapore, Thailand, or around the world. So it's worked out pretty good. And I make a little profit on it, too. Finally, I think we in business, and we are discussing this, because there is no multilateral agreement on investment. That was blown up in the OECD 2 years ago. I won't get into why it was blown up, but absent the government stepping in, we'll do something, and we will figure out how we can leverage what all these countries want, which is basically our investment dollars. So with that, there is no substitute for substance. It is the message, not the medium. Thank you very much.
I'm going to be very brief in my introduction to Ira Arluck for two reasons. One, he deserves the time, and I shouldn't take it away from him. And second, he gave me a very, very short biography. Ira was founder and for over 20 years the executive director of Citizen Action. He founded New Economy Communications, NEC, in 1998 with his colleague, former Congressman Tom Andrews, who's a Democrat from Maine. NEC is a not-for-profit group that provides strategy development and public relations assistance to organizations working on global economic issues. And Ira, the patient Ira Arluck. Thank you, Ira.
Well, the patient. Let me, obviously, if you're the last speaker, you have to reorganize what your prepared remarks were. I suppose I'm here. I'm in the NGO category that Don spoke of, and what I want to go back to is the original question posed in the title of the series, the International Trade and Labor Leveling Up or Leveling Down. I guess I'm in the camp that says for tens of millions, really hundreds of millions of people, actually it is hard to argue that there hasn't been substantial leveling down, and the data certainly reflects that, and I'll talk about that very briefly. And secondly, I guess, there were, as Don Turner was saying, there are those in Seattle who wanted to end those institutions like the WTO, and there were those who were there, like himself and like myself, who are for rules, enforceable rules. And let me begin where I was going to end, actually, because this reference to the whole notion of enforceable rules brings up this question of what is generally referred to as linkage, that is, the enforcement with trade sanctions of core labor rights standards. There's a point that I think needs to be made, and I think that it is unintentionally, I'm sure, but nonetheless, it obscures, I think, the discussion of what the real divide is when you talk about it as a north-south divide. Because if you only can believe that if you look at the leaders of many of the countries that are voicing this in the developing world as, in some sense, broadly representative of the views of many important sectors of their societies. Many of these people make very few pretensions to being democratic leaders, and in many other venues, these are not people whose remarks are given the same reverence that they are when they object to linkage. But if you listen to other voices, let me just give you a couple of examples. I'm not prone to read quotations, but some of these are so simple and elegant, and the source is very important and instructive. For example, on this whole question of linkage, the South African Textile Workers Union in 1999 addressed it. And it's the most succinct statement, but it's repeated over and over again by representatives of workers all over the world. It says, as representatives of workers in the developing world, in the lowest paid part of manufacturing, in the sector of the economy most exposed to globalization, we live daily with the real link between trade and labor standards. As soon as we improve wages for our members, companies move across borders to a country without labor rights. Our members work long hours, often in unsafe conditions, for very little wages. We see our countries becoming havens of exploitation and poor working conditions. We see our countries remaining at the bottom of the industrial value chain, reinforced by governments who call on investors to exploit these conditions. We call, therefore, for the World Trade Organization to recognize the link between trade and labor rights and to ensure that all countries participating in the world trading system abide by a rules-based system which include labor rules, namely compliance with the core ILO conventions. This should be a minimum requirement for countries to receive all the benefits of membership in the WTO. What could be simpler? Let me just so that you don't think this is an anomalous point of view. The General Secretary of the Malaysian Trade Union Congress. Question of core labor standards is a question of human rights. Protectionism has nothing to do with it. If you look at neighboring Asian countries, Malaysian workers are 3 times cheaper than their colleagues in Singapore. But in Indonesia, workers are 3 times cheaper than Malaysians. Workers and trade unions in Singapore are under heavy pressure to lower their wages or see their jobs go to Malaysia. Similarly, in Malaysia, workers risk losing their jobs to Indonesia. Indulge me, one more quote. The president of the Zimbabwe Confederation of Trade Unions. No African trade unionists, nobody elected by African workers to represent them is opposed to linking labor rights with trade sanctions. I'm speaking on behalf of the poorest of the poor. Do you think they would be opposed to improvements in their working conditions? All those who speak out against our proposals for linkage are in reality speaking on behalf of their governments, not the workers. So let me say that I think we're confronted with the two paradoxes that concerning trade, international trade and labor. First, of course, is the dazzling wealth that has undeniably been created by global trade. And second, the fact that per capita income has been declining for the past 15 years in over 150 countries, according to the UN. In 70 countries with nearly 1 billion population, consumption is lower now than it was 25 years ago, in precisely the period during which there's been the most explosive recent growth in global trade. The second paradox, obviously, is that labor rights have been recognized for over half a century. And what's interesting about it, and it's almost inexplicable in American terms, but it is nonetheless the case that the UN in its Declaration of Universal Declaration of Human Rights and all the ILO core labor standards are considered in these world bodies and internationally as not just labor rights, but as basic human rights. Now, virtually no one outside of the labor movement in this country could possibly even fathom what that means, and yet I believe passionately that it is so. But it is right at the core of the problem. That is to say that these labor rights are everywhere recognized, but are routinely violated by the multinational corporations that trade overseas for the most part. So let me, what I think is important, I mean, is just to recognize, and it's certainly not original with me, you have that the process which permits this to happen is the one that I think Dean Voss pointed out earlier, which is that the globalization of production gives corporations enormous leverage over workers, but also over governments. And so you have even the strongest public proponents of free trade, like Tom Friedman from the New York Times, who acknowledge that, I won't bother quoting him, but acknowledge in his most recent book on the subject that, leaders of most major countries are like governors of a lot of American states. They have to attract investors, and they'll do nearly anything they can to do that. And what so frequently happens is they offer up their workforce as a low-wage, unorganized commodity as their competitive advantage. And this violates every internationally recognized law, but it goes on because there are simply no enforcement mechanisms right now. Now, it strikes me that I want to go into just 3 examples, just from my own direct experience. And let me say, the work I've done has focused on the concrete. So I'm one of the people who worked with the organization that brought you Kathy Lee Gifford and Walmart and sweatshops to public view. Let me suggest 3 of the kinds of things that go on that major American corporations do, how it works, and why, at least in my view, it's important to concentrate a certain amount of time, is appropriately done and was extremely well done, it seems to me, by the other panelists, at a conceptual level about trade. But it's important, I think, to look at how trade is done. How it's actually conducted, what really goes on in people's lives before really going back to discussions about free trade. Because when you actually take a look at the way in which many of the corporations operate and what the conditions of their labor force are like, free is an odd word to use to describe it. So let me give you 3 examples, one of which, and these are not, again, these are not marginal, anomalous examples. These are major companies, household names, as you will see. These are major suppliers that are the largest of their kind in their industry. So take the example of Nicaragua, where I was this summer to observe some of this. a Taiwanese-based company called Nenxing that has a plant in the free trade zone in Managua called Chentex, which Nenxing is the largest blue jeans manufacturer in the world. And it's not a huge company, but it has plants in Nicaragua, in Mexico, in Lesotho, and in Taiwan. It is one of the principal suppliers to many of the major U.S. retailers: Walmart, Kmart, JCPenney, and Kohl's department stores. It sells Sonoma jeans. Kohl's, for example, sells the Sonoma jeans that are made in this plant for about $25-30, depending on what's on sale, per pair. It pays its workers 18 cents per pair. The workers had a union. Their first contract, they agreed at management's request not to raise wage issues. They do that the next time. They reopened it at the appropriate time. They asked for an 8-cent increase. They were immediately met with firings, and the details of which are not so crucial here. But the union was virtually busted, and it provoked a conflict, and several delegations of observers went to Nicaragua to interview the workers and some of the plant management and some Nicaraguan government officials. And I had the opportunity to go down there along with Congressman Sherrod Brown from Ohio and some religious leaders, and Charles Kernigan, the a fellow who brought you Kathy Lee, who's the director of the National Labor Committee for Human Rights. And I must say that it's very hard to be prepared for what you saw, because if instead of going to the factory and going inside, where if you talked to workers, assuming you were allowed inside, you couldn't find out really what was going on, because they couldn't take the risk of talking to you, frankly, because it might be worth their jobs. But if you went to their homes, you would actually see what the conditions were for people who worked for supplying major American corporations, and extraordinarily profitable ones at that, with blue jeans. These were people who lived in 8-by-8 hovels, the best feature of which was the dirt floor. The walls were made of 2 walls plastic garbage bag material, 2 walls of cardboard box material. Malnourished children with dysentery. Hard to imagine how people survived day after day. And these were people who worked full-time, forced overtime hours, anywhere from 55 to 70 hours a week. And they were not the exceptions. In fact, many of the people we stumbled across were people we met by accident. Our car broke down, happened to strike up a conversation with someone standing on the side of the road as we replaced the fallen spare tire, took us across to their hovel, introduced us to friends in the neighborhood. Same story over and over again. What is interesting about this as well is Sherrod Brown, the congressman, came back to the U.S. and was so appalled that he wrote a letter to President Clinton that he got 67 of his colleagues to sign, describing this situation. Shortly thereafter, Andrew Samet, the Undersecretary for International Affairs in the Labor Department, goes down. And then, a month later, the U.S. Trade Representative Charlene Barshevsky writes a very stern letter to the Minister of Foreign Affairs of Nicaragua, saying, you really have to clean up this mess at the Chentex plant with respect for human rights, or it could jeopardize your enhanced trade benefits. This is a much more pointed letter than is usually written. The response is usually, especially a small and very poor Caribbean or Central American nation, is to worry a bit. But observers there just didn't see much of a response. And then a month later we discovered why, we think, which is that it was discovered that the Pentagon's Army and Air Force Exchange Service, which is a $7 billion operation that supplies merchandise to the PXs, on the exchange. In other words, they don't make the uniforms, they sell blue jeans and other merchandise at subsidized, very low rates to servicemen and women and their families. They source from exactly that plant. The Nicaraguan government has excellent labor laws on the books, strangely unenforced, and you step back and you sort of ask yourself why. Well, if you go to Nicaragua, you notice 2 things. One is the Taiwanese government has just built the presidential palace, refurbished the Palacio Nacional, rehabilitated the National Assembly building, is building a new Ministry of Labor building and a new Foreign Ministry building. And the Taiwanese companies that are the preeminent ones inside the free trade zone, have said very clearly that unless the government allows them to fire the workers, to not respect their right to have this union or to bargain collectively, they'll pull out. And they will not make the new prospective investment in an additional free trade zone. That, I would submit to you, is much more characteristic of the way in which trade is carried on and the conditions that workers face in developing countries. And to think, to go back to the linkage question, that anyone in the labor movement in this country is foolish enough to think that it would be an effective protectionist measure to grant the workers their wish to increase their wage by 8 cents per pair of jeans sold would bring a single job back to this country or prevent a single job from leaving this country is absurd on its face, which is why that argument is not made by people in developing countries who are closest to and who experience the problem in their daily lives. Let me give you another example. And this involves the world's largest manufacturer of footwear, the Baochen Company in Taiwan, which is, of course, the largest supplier to Nike, the largest retailer of footwear. We discovered that Baochen uses contract labor from Thailand to produce in some of its Taiwan-based factories. And they do this via a system of job brokering in Thailand. So usually rural women, young women, end up having to mortgage their family farms to come up with the fee to the job broker so that they can go to Taiwan and get jobs with Baochen at wage rates that are substantially higher than are paid in Thailand. Sounds like a great deal. What happens, however, is that generally speaking, after people are paid their wages and after deductions are made for a variety of reasons, it takes 2 or 3 years to pay the loan back. But during that time, they serve at the will of the employer and can be sent home to Thailand for virtually any reason under Thai law, under Taiwanese law. They are required to be pregnancy tested periodically, and if they are found to be pregnant, they are sent home. If they are recalcitrant in any way, they are sent home. The independent monitoring organizations that some companies have hired to look at this, as well as various human rights organizations, refer to this as debt bondage. It's virtual indentured servitude. And the result that we learn from eyewitnesses to the process, that is Thais who have returned from Baochen in Taiwan to Thailand, is that the estimates that we've heard is that from 40 to 50% of the women end up being the concubines of the line supervisors and plant managers, because to refuse sexual advances is to mean that you will be returned to your country before you will have been able to pay back your loan, which means that you will have your mortgage foreclosed on and you and your family will be plunged into deeper poverty than you were when you started. Now, this is not a condition that is unknown to Nike. It's been in papers in the U.S., in the Los Angeles Times, in the Bangkok Post, in Taipei. It's been in many, many different places. There are no enforceable international rules to deal with this at the moment. Third and final example, Walmart in China. Among other examples that human and labor rights advocates discovered was the example of the Chunxi Enterprise handbag factory in South China. You can imagine what they made. Kathy Lee Gifford handbags, which of course are sold at Walmart. This was the subject of a 4-minute, 5-minute exclusive on the Nightly News with Tom Brokaw back in April. And so the conditions that were reported were extraordinarily low pay, compounded by the fact that not only are, and again, this is rural, these are usually rural women, 16 to 23, 24 years old, who live in military-like barracks, whose every movement is controlled, who have deductions from their already low pay for food and lodging in extremely overcrowded barracks. They're locked into the factory. Reports are that guards routinely punch and kick workers for talking back to the managers or walking too fast. This is a total and utter violation of Walmart's code of conduct, which it makes all of its suppliers sign. Right? When Walmart was confronted by this with the producers from NBC, they denied having any business relationship whatever to this company. It was just wrong. It didn't happen. It's just manufactured out of whole cloth, they claimed. The next day, when we held a press conference, they hired someone to come and hand out a release flatly denying that Walmart had any relationship to the company. 2 months ago, in Business Week, they admitted finally to the reporters that they'd lied. And that was because they felt, quotes, defensive about sweatshops. This is routine. We don't have enough time, and you don't have enough patience to have me list the number of extraordinarily well-documented cases, which are incidentally difficult, particularly in China, to come by because the fear of repression is so great. But it is frequently just as great in El Salvador or in Lesotho. As long as there are no enforceable standards, there will be no change. And I think I don't exaggerate by saying that many of the resources that are now devoted to dealing with this problem on the part of corporations is devoted to PR and not to actually dealing with the problem. It strikes me that if you take a look at it, you have to say that if any given manufacturer, however large, Walmart or retailer, like Walmart or Nike, were to step out of line and insist on higher pay and the recognition of independent unions and a willingness to bargain collectively, that they would be put at a competitive disadvantage. Which is why these conditions cry out for a broad political solution, namely the implementation of enforceable standards. And we haven't actually come up with anything other than trade sanctions that have sufficient teeth that attract the attention of nations and businesses than that. If there were another vehicle with teeth, fine. But to have on the books for so many years in the face of this type of a reality and to quibble over the forum in which it should take, or to claim somehow that to end practices like these would be protectionist, or to take seriously the comments of political leaders who would offer that up and take that at face value is very upsetting and it's criminal. So let me conclude by saying that there will not, in my view at least, be a change in the direction of what happens to tens and really hundreds of millions of the world's people if a trade regime like the one we have continues. And there's probably a logic to it that stands in the way of any given corporation being courageous enough to step out and behave differently. I'm not sure that's true, but I would be willing to give them the benefit of that doubt on that basis, which means that it behooves them to then seek a general solution which puts a floor under wages based on standards of living in each country as a way of protecting themselves. Barring that, it seems to me the only other route we have, and it's a difficult one, is to sensitize consumer opinion in the developed world, in this country, in Europe particularly, which is happening, so that the price that a Nike or a Walmart might have to pay for continuing to do this, and by doing it, they're not acting in any different fashion than their competitors. In fact, for a long time, they claimed they couldn't reveal where they were manufacturing these goods because it was a trade secret, because they had such a great competitive advantage. And then it was discovered that these same places are putting together footwear for most of the brands. Same with the jeans manufacturers. You know, you've got 8 lines in a factory, and 4 of them are devoted to Kohl's, and 3 to Walmart, and 1 to JCPenney. They all know. Their competitors are the people who know best where all of these things are. But basically what you're doing is creating a situation where one of them, perhaps an industry leader, is trapped. The public is so upset with their behavior that it begins to, maybe it tells their marketing people that if this continues for 2 or 3 years, they're going to lose the youth market, or they're going to be hurt in some way that will affect their bottom line and their share price. At that point, their self-interest changes. Because if they're stuck at having to pay better wages and recognize unions, but their competitors are not, then their self-interest becomes a floor that applies to anyway. Much in the way that 100 years ago, big companies, worried about what they then called cutthroat competition, opted for national standards, which got us things that heretofore were thought impossible. So my sense is, and I'll close, that if it isn't going to be linkage, the burden of proof is on those who would say that the alternative for enforcing these rules can be effective. Otherwise, the discussion really gets obfuscated. So thank you.
I know I have an endless number of questions for our speakers, but time isn't going to permit that. I simply want to thank them, Gary Voss, for his remarks, Wally Workman, Don Turner, and Ira Arluck. We received a tremendous amount of factual information during the course of these presentations, and now it is left to us to digest it and also to assess the variety of opinions that were expressed as well. We have gifts for our speakers if they'll stop before they leave in room 1203. The law school has some gifts for you. And we have a reception following this conference in the room right behind us. You're all invited. Please join us. We'd be delighted to have you. Thank you for coming to the Goldberg Conference.